The final matter to come before the court today is Jeffrey K. White versus City of Cuyahoga Falls. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, come on up. If you're the appellant and you wish to reserve any time, and if you let me know when you get started, I'm keeping the clock this morning and I can keep you apprised of the passage of time. Court's read the briefs and we're ready to see who you are.
Your Honor, my client is here, but I believe he's out in the hall. Is it all right if I get him before we start?
Yes, certainly.
Thank you. I apologize.
He's the appellant? No, he's fine.
May it please the court, my name is Paul Hoffer and I represent the appellant in this case, Jeffrey White, doing business as J.K. White Construction. I reserve 5 minutes for rebuttal. We have raised a number of assignments of error and I'll get right to them. Well, actually, we need to go through some of the facts. In 2010, Mr. and Mrs. Alice decided to participate in a program operated by the Cuyahoga Falls that provided funding assistance so they could remodel their home. As part of the program, they had to fill out certain paperwork and that the City of Cuyahoga Falls provided, and they determined what their eligibility was. In March of 2011, my client was asked to make a bid on this project of the Ellis's, which he did. He was one of 3 bids that had to be made under the terms of the program. As part of that, he had to fill out certain paperwork with the City of Cuyahoga Falls to determine that he was eligible to participate in the program, and that he had certain requirements that he had to fulfill, such as showing that he was able to would meet certain non-discrimination guidelines, that there were certain employees of the City of Cuyahoga Falls that weren't working for him, that they didn't have ownership interest, that how many women were working for him, a whole slew of different things that all refer in those documents to a contract between J.K. White Construction and the City of Cuyahoga Falls. And if you take a look at the brief, we enumerate those, but I can just very briefly state he had to sign and notarize a tracking form that required a contractor to agree to follow certain rules, policies, procedures of the City of Cuyahoga Falls. Not the homeowner, the contractor. That's Exhibit D1. A certificate of compliance with the states that he had entered into a contract with Cuyahoga Falls. Exhibit D2 of the motion for response to motion for summary judgment. Another certificate of compliance saying he entered into a contract with the City of Cuyahoga Falls. Exhibit D3. State of Ohio form that had to be signed in regards to all contracts with municipalities. Exhibit D5 of the response. After he signed these documents, submitted his bid, which enumerated what work he was going to do and what the price of the work was going to be. Denise Bell, an employee of the City of Cuyahoga Falls, then submitted that request to the Board of Control for exactly 1/2 of the total value of the work to be paid by the City of Cuyahoga Falls. And that work was then, that's Exhibit I of that. In Exhibit O, the Board of Control approved it. The document, which I have, I think was very important to see. says that on February 28, 2011, the Board of Control recommended a residential matching grant in the amount of $8,973.50 be placed in community development escrow account on behalf of it. It gives a reference to the job, gives the address, which is specifically refers to my client's work that he was supposed to do. Signed by the mayor, the director of development, Denise Bell as community development block grant, and also then certified by the director of finance. Says it's hereby certified that the amount required to meet the contract, agreement, obligation, payment, or expenditure for the above has been lawfully appropriated or authorized or directed for such purpose as is in the treasury or in the process of collection and the credit of the fund free of any obligation or certification notwithstanding.
Is your client's business referenced in that document?
Not in a specific document, but the amount of the contract is.
I understand.
And the proposal that Ms. Bell provided, Exhibit H, says the homeowner qualifies for residential match grant program. The scope of the project will include completion of an upstairs addition and a bathroom along with kitchen renovation. Project cost $17,947, which is the bid that my client made. J.K. White Construction will perform the work. And that was the proposal that was submitted to the Board of Control, which was then approved by the Board of Control in Exhibit O. Didn't need to have the name because you could take all the documents together, as we pointed out in the case of City of Cuyahoga Falls versus Ashcraft, cited to in a brief, that it's not required to have one singular document, but all of the documents construed together. If you could determine the terms of a contract, then as long as you meet the criteria for a contract, you have a contract. And we did that. And in fact, notwithstanding what the city is saying, you have the director of finance specifically saying that this certifies that this contract met all the requirements of the law. That's right, she signs it. So they got an admission against interest that there's a contract. And on top of that,
I don't think that the city takes issue with the fact that these funds were set aside in connection with the bid that your client had submitted. I don't, from reading the briefs,
they're saying there's no contract at all and they had no obligation to pay our client. We'll get into that in a moment. But the most telling document, again, is in the response. When it came time to actually pay my client would have had to sign a release of lien given to the City of Cuyahoga Falls, which again specifically referenced the contract, not with the homeowner, but with Cuyahoga Falls. And my client never got to that point because they gave the money to somebody else who didn't have to do all the things that my client did. And they had no problem giving the money to Innovative Remodelers, even though they didn't comply with any of this. And they certainly didn't go through the Board of Control, get money set aside for them or anything. They just wrote a check to them. So again, like I said, it's going to that fifth assignment of error. If you construe all the documents together, there's a contract. It's not just the fact of paying money, that my client had to agree to the non-discriminatory policies. They had to agree to not have firearms, that they had to have letter of mediation, certification, that they had to pull building permits, they had to go through all these extra steps that they would not have had to done. It was just a contract between the homeowner and the contractor. City of Cuyahoga Falls put these additional requirements on. In fact, City of Cuyahoga Falls is the one that, not the homeowner, but City of Cuyahoga Falls is the one that authorized him to commence work on a project, and which he did. And if you take a look at what, under the terms of the facts of the case, City of Cuyahoga Falls did not refuse to pay my client because they didn't have a contract or didn't comply with the charter. They didn't pay him because they said he didn't do the work, complete the work. That was the only reason. And then they substituted somebody else in there before the term of the contract was even over. He was supposed to have the work done by June 24th. They already put somebody else in there, which they picked, put somebody else in there, and And then my client didn't even know that they paid the money out to somebody else. He sent a letter in, and then not only after he sent a letter making demand for payment, City of Cuyahoga Falls then rushed out, cut a check to Innovative Remodelers and paid them.
Well, one gets the impression from reading the briefs that had the second contractor in the estimation of the homeowners and the city not done a thorough job, that the city could have refused and probably would have refused to pay the check and would have taken the same position with respect to him, that they didn't have any contract.
But that's an issue of fact that was never reached in the motion for summary judgment.
What is an issue of fact?
The fact of whether the work was completed or not. We haven't had.
Oh, right. You don't get to that because the court ruled that there was no contract.
But again, the court has to construe all the evidence in favor of the non-moving party. And he's saying is because that one document doesn't specifically say J.K. White on it. If you read the decision, the Exhibit O, because it didn't specifically name them, even though it states the amount of the one half of the agreement, even though it references the project number of the agreement, and all these other documents refer to a contract where my client was supposed to do the work. And you take all those things together with that document, you certainly have a contract, or at least construing the evidence most favorably to my client, which is what the standard is for a summary judgment motion.
And you're just now reaching into that 5 minutes time. You may
Okay.
continue to reserve.
All right. Just very briefly, I just want to touch on the sovereign immunity argument. This argument about the charter is an aspect of sovereign immunity, and the fact of the matter is that even after they filed a motion to dismiss, which was they didn't have a copy of a written contract attached to the complaint, which had nothing to do with sovereign immunity, even though they filed a motion for summary judgment where they raised it, they never filed an answer or defenses until afterwards when the court said it wasn't right for dispute. And when they did file their answer, they didn't raise the defense of sovereign immunity, which was an affirmative defense. Then he filed a supplemental brief raising this issue about, again, the charter, which is an aspect of sovereign immunity, which they weren't entitled to raise because they never raised it as a proper defense in this case. Thank you.
Good afternoon, may it please the court. My name is Janet Ciatola, and I represent the city of Cuyahoga Falls in this matter. As set forth in the city's brief, all of the appellant's arguments can basically be boiled down to two issues as we see it. First, whether or not there was a procedural violation of Civil Rule 12-56, and second, whether appellant's able to recover under breach of contract theory. Regarding the first issue, appellant argued the trial court erred when the court converted the city's motion to dismiss into a motion for summary judgment, and the court erred in not striking the charter from consideration. Ohio Civil Rule 44.12 states a court may take judicial notice of a municipal ordinance within its territorial jurisdiction. Since the city of Cuyahoga Falls is within Summit County, it's clearly within the court's territorial jurisdiction. Also, appellant argued that the conversion of
Well, did the court say that it was taking judicial notice of the charter?
No, I just believe the court considered the charter.
Based on what? You said you think it considered it, based on what?
Based on the ruling, the court
Because
signed.
of its references and so forth. All
Yes,
right.
in the judgment entry. Yes.
Well, how about the argument, and counsel did not refer to this during oral argument, but certainly did in the brief, that the court appeared to suggest that once a motion for summary judgment was filed and matters were attached that were not, that were outside of the four corners of the complaint, that it must convert to summary judgment rather than it must decide whether to consider the attached matters. To counsel, to your colleague's point, did the court miss a step? And in missing that step, did the court fail to exercise discretion because it didn't think it had discretion?
It's our position, we don't believe so, since there was such a reasonable opportunity to fully conduct discovery, to take depositions. The court, when it made its ruling, the city had filed a motion for summary judgment, I believe, at the beginning of April. On April 24th, the court said they were going to convert the motion dismissed into summary judgment, given response time at the end of May of 2013. The parties then, plaintiff filed a motion requesting for an extension of time so that discovery can be conducted. The court gave an additional 120 days. Depositions in the case were taken. Discovery was exchanged. I have 2 banker boxes of discovery with this file. And the city filed a motion, its motion for summary judgment in June of 2013. They responded in September of 2013, and then conducted a later pretrial and gave the parties even another opportunity to supplement briefs in March of 2015. So I believe that the courts allowed this case to everybody to flesh out the issues, conduct discovery, and use the motion for summary judgment as a tool to manage the case.
And during that time, when discovery was going on and once the court indicated that it would convert the motion, did the appellant raise the issue before in the trial court that the trial court had improperly converted the matter to a motion for summary judgment based on its not exercising discretion?
No, I do not recall. I just know this court is priorly determined in the case of WFM acquisition versus Seger-Mestrovich that the court needs only to give parties the opportunity to provide additional briefing and evidence before ruling on a converted motion and dismiss. Going to the second issue, in this case, the appellant claims that he's entitled for recovery under breach of contract law. Again, I would indicate that the record is devoid of any written contract between the parties that was prepared by the Director of Law, signed by the Mayor, and certified by the Director of Finance. These are requirements that are set forth in the city's charter and give the city the authority to enter into binding contracts. And without proof of that, appellant's claims must fail. The rest of my arguments are addressed in the brief. I have no other argument to make. Welcome any questions you may have.
Seeing none, thank you, counsel.
Thank you.
Counsel, you have just under 4 minutes remaining.
Yes, Your Honor. Addressing the first point with respect to the motion to dismiss, if you take a look at the docket, we certainly did file an objection or a motion for reconsideration saying that you can't, you have to, first of all, you do have the discretion on whether to grant a motion to dismiss or not, and the court denied it.
I guess what I'm asking is, did you raise the precise issue that you're raising?
Yes.
For us, that the trial court did not consider whether or not to consider the... We
did in the motion. In the motion to reconsider that was filed early on. But again, the problem is that they put the cart before the horse because they never filed, no answer or defenses were raised. And when they were raised, they didn't raise the answers or defenses that they raised in their motion for summary judgment motion, which is the issue of this case. You're saying is, well, the charter says you have to have the law director prepare a contract. Well, they didn't have to prepare a contract in order to pay innovative remodelers. There's no evidence that they said the record's vacant of that. That's true. The law director may not have, but they had certainly approved the forms, and he was certainly a member of the Board of Control that approved the payment of the contract. So, I mean, the fact of the matter is that you have all these types that say contract on it. You have a director of finance saying that we certify that all the procedures of law have been followed. The law director was there and said, well, wait a second, I get to prepare a contract, and he didn't object to that. And then they pay the other guy who didn't prepare a contract either and say, well, he's entitled to be paid, but you're not. So we're going to steal your services and your goods that you provide, but we're going to pay this guy over here. I mean, what kind of result is that? Is that the city of Cuyahoga Falls basically has an out for every single contract, because how many contracts are ever prepared specifically by the law director?
Maybe none under this
Yeah.
program.
So basically, they've got themselves an out so they can pick and choose the winners and the losers. But the fact of the matter is that the law director was a member of the Board of Control, and he certainly approved the process because he was part of the process. And to tell me that all these forms that they prepared, that are having people sign to get paid thousands of dollars, were never run by the law department, I mean, that beggars imagination. And that would be, again, it wasn't even raised in their answer defenses. Again, that's a sovereign immunity argument. It's an affirmative defense. They never raised it. Even after the court said, oops, I made a mistake in granting this motion, converting this motion to dismiss to a motion for summary judgment. This record's not right because you didn't file an answer in defenses. Please do that. And then they did it. They didn't raise the defense. And then they filed supplemental briefs saying, we're still going to raise the sovereign immunity argument because that's what we raised before. And even though regular contracts don't need to follow that procedure, they didn't follow. Even after the court gave them the opportunity, a second, third, fourth bite at the apple, they didn't do it. And then they want to come back and say, we're not entitled to relief because we didn't follow the law. And
But under the parameters of this program, at what point would your client be required to file a release of lien?
at the time that he was to be paid, in order to actually have the check cut, he would have to provide that release of lien. And again, if you take a look at that release, not only was he giving, releasing a lien against, as the city of Cuyahoga Falls, he was also giving the city of Cuyahoga Falls a warranty that his work was done correctly.
Okay, thank you.
Thank you.
Thank you both for your presentations this morning, this afternoon. Court will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on the Ohio Supreme Court website, which can be linked to through the 9th District Court of Appeals website. Thanks. We are adjourned.